Good morning. Welcome to the Kansas Court of Appeals session. We're meeting remotely today, and we appreciate your attorney's willingness to do that. My name is Catherine Gardner, and I'm serving today as the presiding judge. And with me today is Judge Henry Green and Judge Michael Boozer. So I will keep time for us today. So appellant, if you'd like some rebuttal time, just let me know. We're going to go ahead and call the first case, which is the Board of County Commissioners of Johnson County, Kansas, appellant versus Doug Jorgensen, State Fire Marshal appellee. So let me first just take your appearances, please.
Bob Ford for Johnson County, Your Honor.
Thank you.
May it please the court, Assistant Solicitor General Dwight Carswell on behalf of the State Fire Marshal.
Thank you. And I would also just acknowledge that we do have an amicus brief by Interhab Inc. today. So Mr. Ford, you may proceed.
Your Honor, I'd like to reserve 3 minutes for rebuttal.
Thank you. And this is a 20-minute argument case.
Yes, it is.
Okay, go right ahead.
Your Honor, I apologize. I'm trying to start my clock. I know you said you'd take care of it. There we go. I'm sorry. May it please the court. Your Honors, Johnson County raises several challenges to the fire marshal's actions. They all deserve your consideration. But the heart of the argument is that imposing stricter safety measures on group homes and refusing to treat group home tenants as a family are well-recognized discriminatory housing practices.
Before you get to that, could you squarely address the issue that I think was not raised in district court, but that both parties have briefed a little bit, which is the question of standing. Standing
Sure.
goes to our jurisdiction to hear the case, and so we're very interested in that. But how does the Johnson County Board of Commissioners, how is it an aggrieved person under this handicapped housing laws that you cite?
Your Honor, the Federal Housing Act permits anyone that's been aggrieved by housing discrimination to bring an action. That's 42 U.S.C. 3613. Under our Kansas statute 77-611, a agency action directed at an individual or a group is confers standing on the person who the final order is directed to, which is in this case, the county.
So that would give you the ability to appeal under the KJRA, but it doesn't make you an aggrieved person for purposes of discrimination acts. I mean, there is the Kansas Act against discrimination in housing, which defines an aggrieved person, I think, identically to the Fair Housing Act. But it looks like all the cases you've cited and others that we've seen in our research, the plaintiffs in similar circumstances are always the residents, the potential residents, or the owner operators of the group homes. It's never a county entity.
Well, it may never be a county entity, and in that regard, this case might be a little different because you don't have one governmental entity bringing action against another, but the county is a housing provider, and most of the cases, I think, that the county cited, including the Horizons case and the Gertrude Barber case, are housing providers or service providers where that issue has been raised. In fact, in the Horizons case, the district court, as a preliminary matter, walked through those issues of exhaustion and standing and cited federal court, including the United States Supreme Court, that held that for the Fair Housing Act, the standing is probably the most liberal of any of the standing requirements because housing providers are impacted when individuals with handicaps are discriminated against. So I think the cases actually do address that pretty clearly. And Horizons, again, went through a kind of a synthesis of law on standing. That's almost always raised whenever a housing provider brings an action. And also remember, many of the cases the county cited are cases where the Department of Justice either was the plaintiff or filed an amicus brief or intervened in the case. And obviously in those cases, the DOJ was not providing services, but it raises those standing questions and addresses them. So I think it's pretty clearly established that housing providers, just like Johnson County, service providers like Johnson County do certainly have standing under the federal act.
Does the record show what the relationship is between the county and JCDS that I think owns most of the homes? Is that correct? JCDS owns most of the homes you're talking about today?
No, that's incorrect. The relationship between Johnson County and JCDS is a department of Johnson County government.
But you're saying it's incorrect that JCDS owns or operates the homes, most of the group homes we're talking about today?
Most of the group homes are owned by private landlords, by organizations, I don't know if they're even organizations, support groups, private landlords. You know, there's a variety of ownership methods.
That the record shows.
I believe the record shows that, and I believe my petition lays that out, and I don't believe that's a disputed fact in this case.
Thank you.
Coincidentally, April this month is National Fair Housing Month. It's been 53 years since the adoption of the Fair Housing Act and 33 years since those with a handicap were added as a protected class under that federal statute. Housing discrimination occurs when a distinction is made between those who have a disability and those who do not. Such a distinction is invalid because it makes it more difficult for those with a disability to obtain housing that's available to everyone else. The district court's decision should be reversed because it allows stricter blanket safety requirements for group homes as a direct result of the tenant's disabilities. If the decision stands for non-disabled tenants, such as college students, have access to housing under single family rules, but the same number of tenants with special needs do not. That is facial housing discrimination.
Counsel,
Go ahead, Judge Boozer. Go ahead.
let me ask you, on the brief of amicus on page 7 is the following statement, quoting the Bangerter 10th Circuit case. And the statement is, a policy may permissibly discriminate against persons with disabilities if it is predicated on public safety or if it is beneficial to disabled persons. Do you agree with that statement?
I do. I do agree with that statement. But
Do you believe that the state fire marshal in applying these regulations is attempting to improve public safety with regard to fire and explosion?
I don't know what the fire marshal is attempting to do in this case.
Really? I mean,
Yeah.
do you have any evidence that he has animus against people with disabilities?
I don't believe, I don't believe that the fire marshal has any animus or ill will towards those individuals who are disabled.
Could it be that his purpose in adopting and applying these regulations is to carry out his state authority as state fire marshal to protect citizens of Kansas from fire?
I believe that probably is his purpose. Yes.
All right. Then do you agree then with the Bangerter statement that just because there's discrimination against persons with disabilities, it may be not actionable if it's predicated on public safety or is beneficial to disabled persons?
Your Honor, that statement, taken out of context, doesn't answer your question. Your question is really, is it proper to impose stricter safety regulations if you think you're doing it because it helps the disabled? That's really your question, I think. Safety as a rationale, which is what the fire marshal is basing its regulations on. Safety has been rejected as a legitimate basis to impose more stringent rules on group homes for the disabled. The Bangirder decision out of the 10th Circuit followed the 6th Circuit's decision in Marbrunak. Marbrunak was a 4-person group home where the same type of life safety code provisions were being imposed. Special windows, special doors, special wall coverings, special locks on doors, interconnected fire alarms. And Marbrunak looked at that and said, these are blanket regulations. You can't just impose these on the disabled because you don't impose them on everyone. The public safety exception, which is what Bangirder was referring to, it was a statutory public safety exception found in the Federal Act. That doesn't mean that you can impose stricter regulations just because you're doing it for, quote, safety. That exception was to make it clear that individuals, because of their particular individualized characteristics, pose a danger to the public. And I give you an example of that. If these homes were being occupied by reforming arsonists, you could legitimately say, you know, those folks might be a danger to the public. But saying an individual who has a mental or physical disability is a danger to the public is a bridge too far. That's exactly what the law was designed to prevent. And the Kansas Attorney General's office in 1989 issued an opinion that said, under this new federal act, it is unlawful to impose stricter regulations on a home when occupied by a group of disabled individuals if those same restrictions are not imposed on a family or a group of unrelated tenants of equal size. And that's what's happening.
Let me ask you this. You mentioned your hypothetical about reformed arsonists. In this particular case, we have individual evidence, as I understand it, that a fire drill was conducted in one of these homes, and the residents, it took them 17 minutes to exit the structure, which, according to the standards that are set up by the fire marshal's office, regardless of who's in the home, whether it be reformed arsonists or individuals with disabilities, that's too long, that's not safe, that imperils their livelihood. Isn't that a sufficient basis to have enhanced fire safety protection?
Oh, absolutely not. Your Honor, in fact, if the individuals could not evacuate their homes at all, for whatever reason, if they were in a wheelchair, a walker, if they were in an iron lung, they have the same right to live in a single family home under single family rules. And the fire marshal can't say, because you're too slow, we're going to impose these stricter requirements. In fact, Your Honor, it doesn't even work that way under the fire marshal's regulations. This was one drill, one time at night, a single drill, and it was too slow. But under the fire marshal's own life safety code, a single drill is of no consequence. All a single drill requires is more drilling. It's like a practice test. Just because you do poorly on a practice test does not mean you're going to flunk the final exam. And in this case, the record reflects that the county did more practice and the evacuation time improved. But the evacuation provision has actually been struck down by one federal court, and the county cited that case. In fact, there's more than one case where they call it, well, there's a name for that, where an individual cannot get out of their home. And there was a HUD example in one of the HUD circulars where a person that was in a wheelchair wanted to live on the 14th floor of a building. And the hypothetical question was, could you deny them the ability to live on the 14th floor and say you need to live on the first floor for their safety? And HUD said, no, you can't do that. If they want to live on the 14th floor, even though they cannot evacuate in a fire, that's their right. Safety is always the basis, Your Honor. It was the basis in Claiborne Living Center, which was a pre-Federal Act case. The city of Claiborne tried to base its regulations on safety. If safety was allowed as a basis to discriminate, none of these cases would ever be successful. Because a regulator would always say, we're just doing it for their safety. That can't be the law for disabled individuals.
Let me ask you a related question that goes back to the FHA. How they define discrimination under the subsection F1 you've alleged. It says it's unlawful to deny a dwelling to any buyer or renter because of a handicap of a person intending to live there. Most of the cases you cite are zoning ordinances where the group home owner or operator is faced with restrictions on where they can build a home or how they have to build a home to comply with these codes. That's not what we have here. But my question is, what evidence do you have here that the fire marshal's acts will deny a dwelling to these group home residents? Now, I think there was some reference to one affidavit about a Lula house, and that's all I saw in the record. Could you speak to that, please?
Sure. There was an affidavit that the fire marshal's actions in the past had scared away, basically, private landlords who would make their homes available for disabled tenants. But once they learn of the fire marshal's requirements, they back away and don't want to do it because it's too difficult.
So that wasn't even in relation to this particular citation by the fire marshal? It was in the past?
Well, yes, that's the history. That's the history of the fire marshal's regulations. In connection with these notice of violations, the fire marshal's notice of violations would require one or two of the tenants in these homes, because they have 4 or 5 tenants. One or two of these tenants would have to move out in order to fall within the fire marshal's exemption for 3-person group homes. Because the way the fire marshal's regulations work is, if you are disabled, regardless of your disability, you may not be able to move at all. You may be completely and totally disabled. If there's just 3 of those tenants living in a home, fire marshal doesn't regulate that at all. Doesn't regulate that 3-person group home at all. But if a 4th person moves in, like at Lula, or a 5th person, then the fire marshal, that's a bridge too far. That, the fire marshal says, undoes the life safety code, undoes the fire prevention code, because that 1 person, now we have 4. Well, in the Lula home, that 4th person is going to be denied equal housing. And this is how it denies it. 4 college students can live in a home without being regulated by the fire marshal. A family can be, of any number, can live in a home and not be regulated by the fire marshal. When 4 or more disabled individuals move in, the fire marshal is all over that. That denies disabled individuals housing that is equal to what everyone else can obtain. And that is the linchpin of the federal act. All you have to do is compare what limitations are there on a family or a group of unrelated individuals in the same number. and what restrictions are placed on those with a disability. If those are different, discrimination exists. That, all the cases the county cited, probably the majority are zoning cases. But remember, right out of the box, and this is in the Kansas Fire Marshal's, the Attorney General's opinion, the legislative history expressly states safety regulations, health and safety regulations are declared invalid by this act if they're not imposed on everyone else. The act allowed zoning to continue. It didn't invalidate all zoning. Cities can still try to zone within their jurisdictions, but these cases arise because the cities go too far and impose zoning regulations that either disparately impact or directly impact those with a disability.
Mr. Ford,
I'm out of my time. I'm happy to continue, but I realize I've gone past my time.
Well,
Yeah,
we'll just ask you a few questions.
Okay.
yeah, I've got a question. Was it your burden under the KJRA to exhaust your administrative remedies?
Yes. I mean, yes.
Before filing in the district court?
No. Those are two separate questions. We did exhaust our administrative remedies. That's the district court found that, and there was no cross appeal from that decision. So, we did exhaust, but.
Let me ask you this.
Okay.
Because as I understand both parties, the court made its ruling based on both parties saying that there was exhaustion of remedies. But is that correct?
No, Your Honor, that is absolutely incorrect.
All right, so you say that you did exhaust your remedies, correct?
Yes.
All right. Was there an agency hearing in this case?
Your Honor, the fire marshal said there was.
Well, my question is, what's your position? Was there an agency hearing or wasn't there? What's your legal position?
Our legal position, Your Honor, is that the agency refused to hold a hearing. The agency said there was a hearing. The agency said they had already issued a decision. The agency said that they would not do anything further until we either sued them or the legislature changed the statute. So,
All right, so the answer to my question is that you do not believe that an administrative hearing occurred in this case.
an administrative hearing did not occur in this case.
All right, thank you.
If I may add to that, there is no requirement to exhaust state administrative remedies in order to bring an action under the federal act.
All right, I thought you had just told me that it was your burden to exhaust administrative remedies.
I thought the question was whether under the KJRA,
Right, that's the
we
question.
are required to exhaust your administrative remedies. And under that act, under the act, you're required to exhaust except when you're not. And in this case, we were not required to exhaust. But under the federal act, which we brought two claims, Your Honor, we brought a state statutory interpretation claim under count 1, and under count 2 of our petition, we brought a federal action under the Fair Housing Act. Under the Fair Housing Act, we're not required to exhaust administrative remedies, and we're not required to go through the procedure that they wanted us to go through under 31-136, which is to require a waiver or ask for a waiver, even though we told them they could consider our request as a waiver under that act if they wanted to. So there's different burdens, and to the extent that our state statute is different than the federal act trumps our state statute as far as exhaustion and ripeness and those kind of issues. And that case has been decided.
I have a separate question that sort of relates, because what you had to do under the Federal Act before you came was to try to make requests for reasonable accommodations. So I know you're alleging a breach of that clause as well, but it's pretty clear that the reasonable accommodation standard cannot require a fundamental alteration in the nature of the program. And isn't that what you were requesting? You wanted the fire marshal simply not to apply any of these safety provisions that were triggered because you had 4 or more persons that needed care in this one home. So how is that reasonable to request them simply to overlook their safety violations?
Your Honor, that was the characterization that the fire marshal raised. That's how the fire marshal mischaracterizes our reasonable accommodation request. Our reasonable accommodation request falls in line and is exactly the same accommodation request that is often asked, found reasonable and found necessary. It was to treat these individuals as though they were a family. Treat these individuals as though they were not disabled. Treat these individuals as you would college students in the same number living in the same homes. We did not ask for an exemption from anything. Simply treat us as a family. Whatever flows from that under their regulations. The reason they bring that to you in that posture is because the fire marshal knows the legislature has so narrowly constrained its authority. It has no jurisdiction over any residential or commercial buildings in Johnson County at all. It does not regulate residences in Johnson County at all. But here it's doing that. And what we've said is these are typical single-family residences. They comply with all local regulations. Group home tenants are defined as a family. You don't regulate family occupied dwellings. Treat us the same as you do those folks. And then everything falls in line. Your Honor, the difficulty here is these are disabled individuals. The Fair Housing Act also prohibits discrimination against, also bars racial and gender discrimination. The district court understood racial and gender discrimination. If 4 men were allowed to live in a home under one set of rules, but only 3 women were allowed to live in that same home under those same rules, that's housing discrimination, and it's based on gender.
Okay, I think we're going to have to move on. And you did answer my question. Any other questions by the panel?
No.
Okay, thank you, Mr. Ford.
Thank you.
Mr. Carswell, you may proceed.
May it please the court. The state fire marshal's application of the life safety code to these group homes is consistent with both state and federal law. Since Johnson County didn't really get into the state law claims, I won't either unless you have any questions. But turning to the federal question, I think the best place to start is with the statutory text of the Fair Housing Act. 42 U.S.C. 3604 prescribes different ways in which the Fair Housing Act can be violated. The only provision that might come into play here is F1, which makes it unlawful to discriminate in the sale or rental or to otherwise make unavailable or deny to any buyer or rental because of a handicap. Now, the state fire marshal is involved in selling or renting houses. So the only provision there that might apply is that to make unavailable or deny. And that's the provision that courts have sometimes relied on in the zoning context, where a house is excluded from a certain area by zoning a group home. But zoning is fundamentally different than fire codes. Fire codes don't prohibit where houses can be located. So Johnson County would be required to show that the fire code, to even come under that provision, has the effect of making housing unavailable or denying housing to handicapped individuals. And there's simply no evidence of that in the record. The only thing that even approaches that question is a single affidavit from the Johnson County Developmental Support Director, Executive Director, which says that the owner of one particular apartment or house rather, says he won't pay for a sprinkler system. There are a number of issues with that. First of all, that wasn't even submitted until the petition for reconsideration at the agency level. But even overlooking that issue, the sprinkler system requirement, which is the only thing that addresses, is only applies when it takes longer than 3 minutes for the residents of a group home to evacuate. By Johnson County's own claim, that house is now under 3 minutes. If that's true, I don't know, but if that's true, then the sprinkler system wouldn't even apply, and so there's no problem there. Secondly,
but Mr. Ford hasn't really relied on that when I asked him what his evidence was that the fire marshal standards were denying housing to handicapped individuals. He said it's mostly the fact that you can have 4 college students there, or you can have 3 handicapped persons there, and the 4th one would have to move out. So what do you say to that?
well, that's just not true. You can have 4 there as long as you have certain, or 4 or 5 or 6 or however many you want, as long as you comply with these fire code safety requirements. And as the district court held, yes, fire code requirements sometimes have costs. These are relatively minimal requirements for the most part, assuming they can evacuate within 3 minutes. But they have costs, but there's no evidence, as the district court said, that these costs are prohibitive, that they've in any way have denied housing to disabled individuals.
Is it true then that the only evidence of denial, as you're speaking of, would be that one affidavit about the Lula Street house?
That's the closest. And again, as I said, I don't think that is really any evidence because it only addresses the sprinkler system. Secondly, it only says the landlord won't pay for it, but under KDED's regulations, it's ultimately Johnson County Developmental Services that's responsible for ensuring fire code requirements, so they could pay for it. They also operate and own some other homes that you can arrange these situations. If you have a group of individuals who do take 17 minutes to evacuate, you could house them in a home that has a sprinkler system already, or that Johnson County, through the Friends of Johnson County Developmental Services, operates or owns.
How many group homes are we talking about in this case?
I do not know. That was not specified. I know the fire marshal asked Johnson County that question, and Johnson County would not give an answer. There are records regarding 2 specific group homes that were cited. Now, those particular citations are not before this court. Those are separate proceedings, and there's been no final order with respect to those. But this is a request for a total exemption for all group homes. But yeah, Johnson County wouldn't even give us a list of group homes that are involved. So I don't know the answer to that question.
Thank you.
There is evidence that some of them are owned by private landlords. Some are owned either by Johnson County Developmental Supports or its affiliate, the Friends of Johnson County Developmental Supports. So even if you get past that initial fact that there's no evidence regarding making housing unavailable or denying, Johnson County would still have to prove discrimination. And they haven't done that. The regulation itself, the Life Safety Code, isn't based on a resident's disability. It's based on the provision of personal care services. Now, Johnson County
Well, that is sort of one and the same thing, because under the ADA and the FHA, you define a handicapped individual or just disabled person as somebody who's substantially limited, I think, in one of their major life activities or their daily activities of living. And one of those daily activities is the ability to care for oneself. And that's the term that we're using here to talk about. So how is that not relating to handicapped persons or disabled persons?
Well, there certainly is a correlation there. I don't deny that. But again, a correlation alone is not sufficient to prove discriminatory intent. Instead, you have to show that the standard, in this case, the personal care services, was adopted because of its effect on the disabled individuals. To give a classic example from the equal protection context, in Massachusetts, Personnel Administrator of Massachusetts versus Feeney, there was Massachusetts had adopted a veterans preference that, and at that time it was in the 70s, this was a US Supreme Court case. Veterans were predominantly men. And so the question was, well, is that a discriminatory intent just because there's that strong correlation there? And the US Supreme Court said, no, there's not. You have to show that the classification was adopted because of, not in spite of, the effect on the protected class. And so here, personal care services, yes, those are often going to be required by disabled people. Not all disabled people. There are going to be some intellectually disabled people who can live on their own without receiving these support services. But there is a correlation there. But that correlation alone does not prove discriminatory intent.
But if it applies only to handicapped or disabled persons, that might be different. Can you give an example of a group home that where we're talking about a residential boarding care occupancy, that where somebody doesn't need personal care services?
Well, it's possible. I mean, it's not just group homes, obviously. Another example would be assisted living facilities. So you could have someone an older person who maybe doesn't quite meet the standard of a substantial impairment, isn't quite disabled, but chooses to live in an assisted living facility and receives personal care services, even though they're not technically disabled. They may be limited in some way, but it may not rise to that substantial limitation. So I don't know that there's going to be a correlation, but it's definitely not one-to-one by any means. And moving on, even assuming this regulation did single out disabled individuals, as has been alluded to, there are cases holding that regulations that are designed to protect the safety of residents, as in this case, are permissible as long as they're tailored to the needs of the individuals and aren't based just on stereotypes. And
Now, do we have any evidence here of what the particular needs and abilities were of the people in these group homes?
The Life Safety Code itself, yes, is tailored in two ways. First of all, the residential boarding care provisions only apply when the residents require personal care services, which is defined as protecting the safety of the individuals. So these are individuals who, by definition, need special assistance to ensure their safety. So that is the first fact. And then secondly, the residential boarding care provisions are based on evacuation times. So which requirements apply depend on whether it's prompt, slow, or impractical evacuation. And so, for instance, in the Lula home at the time of the inspection, there was a 17-minute evacuation time, and that's what triggered certain requirements. If there were a lesser time, as Johnson County now claims, there'd be different requirements. So these requirements are actually based on the needs of the individuals and their ability to care for themselves. And secondly, even if the Life Safety Code were in some outlier instance overbroad, there is a provision where Johnson County could come in under KSA 31-136 and request an exemption from the code, say that this particular requirement is unnecessary based on the particular factors of these residents.
So isn't that really what they did during your reasonable accommodation, is to request an exemption under that sort of a waiver provision?
It was, as we understand it, but it wasn't based on that requirement requires showing that the specific requirement of the regulations is an undue burden or a necessary hardship, rather. What they requested is just a complete exemption. They want all these homes treated like single family homes that are not subject to the fire marshal's jurisdiction. And under the reasonable,
Let me back up to something I think you just said, which was that the fire marshal did not impose all of the same regulations to all of the group homes. Some of them had this restriction or this requirement under the LSC, and others had different requirements under the LSC based on evacuation times or other factors.
Yeah, the various requirements are based on evacuation times, the three different categories of evacuation times. So for instance, the sprinkler system requirement, that's only required when the residents of a home can't get out in 3 minutes, at least as long as there's less than 8 residents, which all these have. So, and there are a bunch of other examples, but yes, the provisions are tailored to evacuation time, which makes sense. That's probably the most important factor when it comes to life safety, is how quickly someone can get out of a home in the event of a fire.
Is there any evidence in the record that the evacuation time in question that was 17 minutes subsequently improved to be less than 17 minutes? Is there any evidence in the record?
Within the record, I believe there's at least an assertion of that. I don't know. You go to evidence. Now, I mean,
would that have been in the affidavit?
No, that was not in the affidavit. I think it was maybe in a pleading. I know outside the record, there's also at least that assertion. Whether the fire marshals verified that, I don't believe that's the case, because Johnson County won't allow any kind of inspection or anything.
Well, we don't usually deal with assertions or pleadings. We're wanting to know what the facts were and what's established of record. We're the Court of Appeals, and that's all we deal with. So since there was no hearing here, what facts have you got to support your position?
Well, the facts regarding evacuation time, that is in the record regarding the 17 minutes. There's nothing in the record showing less than that, is what I'm saying. Now, again, what we have here is not an appeal from those particular violation notices. That can go forward once this case is resolved. Initially, it's a kind of complicated procedural history, but those are separate from this case. We have here just a complete request for exemption, and And yeah, there's no fact showing that these residents, that either these provisions make housing unavailable or deny housing, or that these requirements are unreasonable in any way.
What's your position on the Johnson County's standing to bring the discrimination claims?
They cited cases that support their standing. I looked at those, and it seemed to me like they probably did have standing for two general reasons. One, so Johnson County, we're talking, that's the term we're using, but it's Johnson County Developmental Supports, which is an agency of Johnson County that operates these houses. And under KDED's regulations, they're ultimately responsible for ensuring compliance with the fire code. And so I think because of that, they probably do have standing, and they'd also could incur costs for that reason. So now those cases are, as I believe, all lower federal court cases. So this court could disagree with that. It's obviously your duty to ensure standing, but to me, at least, it appeared like they had standing. Turning to their reasonable accommodation request, well, I do think they probably have standing. I don't think they have the ability to request a reasonable accommodation. The reasonable accommodation is for handicapped individuals, not for the operators of homes. And there's no evidence that Johnson County Developmental Supports is acting as an agent of the residents in requesting a reasonable accommodation. And so that's not proper in the first place. Now they could, under KSA 31-136, request a waiver of or an exemption from state fire marshal code requirements. That's separate from the Fair Housing Act reasonable accommodation claim. But again, that has to be tied to specific requirements that cause an unnecessary hardship. And there's no evidence of that here. And even if Johnson County could request a reasonable accommodation, saying that the state fire marshal can't regulate these homes at all, even regardless of how long it takes to evacuate, even if it takes 17 minutes to evacuate, that's just not reasonable. Accommodations, whether they're reasonable or not, would need to be based on particular aspects of the home and the abilities of the residents, not just an across the board exemption. That by its nature is not reasonable.
Did the fire marshal offer? Well, it seems to me Johnson County, for its accommodation, said we don't want any of these regulations in the life safety code. But did the fire marshal suggest counter with some lesser application of the standards from the code?
Yes, the fire marshal, in denying the petition for reconsideration, and maybe even in the initial order, I can't remember, said, look, if you can show that with regard to any particular house, that any particular requirement is an unnecessary hardship, we'll consider that. So yes, on a case-by-case basis, the state fire marshal certainly indicated his ability, as he would be required to under KSA 31-136, to consider specific exemptions when there has been a showing of unnecessary hardship. But what the fire marshal said we're not going to do, and that the only issue before this court right now is whether they should be completely exempted from the state fire marshal's regulatory authority. And again, we don't believe that's reasonable. Unless there are any further questions, just urge you to affirm the district court.
I have one question. That this issue of what constitutes a family is in this case, and as I understand it from the life safety code, or maybe it's Kansas statutes in other areas, that they discuss that family may be as defined by state, county, localities. And it does seem that in Johnson County, you have a number of cities, Overland Park, Olathe, Lenexa, that have, and this is of course due to discrimination from years ago when these group homes were originally set up, I believe, that they refer to families more in the context of, which would include a group home with individuals who are not biologically related, for example. Do you think those local definitions of families, how do you think that affects the ruling in this case, the district court's ruling?
I don't think those definitions are applicable. There are two ways that family comes into this. First of all, that exemption in KSA 31-133 that says the fire marshal can't regulate buildings used wholly as dwelling houses for no more than two families. And their family is not defined, so you just use its plain meaning, which we don't believe encompasses unrelated individuals who happen to live together. And a local definition of family wouldn't control what a state statute means. So, for purposes of the statute, they're irrelevant. Now, under the Life Safety Code, that's where it includes that provision you cited about you look to other definitions elsewhere. But the Life Safety Code itself defines pretty clearly a 4-person threshold for residential boarding care facilities and for 3 or fewer for single-family home classifications under the Life Safety Code. And so that controls here regardless of whether these individuals are considered family. There's 4 of them, so in these homes, by 4 or 5 in the homes that we're talking about. And so that'd clearly be residential care and board facilities. I'd also note that the local definitions, those kind of rise in the zoning context because there are single-family zoned areas, that's the definition. And so you define a group home residence as a family to allow those homes to be located in those areas. But carrying that definition from a zoning context over into a fire code context is inappropriate in our view.
Thank you.
Unless there's anything else, thank you.
Thank you. Mr. Ford, you have 3 minutes.
Thank you, Your Honor. At the district court level, the district court asked some questions that kind of go to the same issues that have been raised today. And it didn't really dawn on me at the time that the district court really didn't understand that this act, this federal act and the counterpart was intended to stop exactly what's happening here. Those statutes, our state and federal statutes, are directed at this very statute, or in the statute and these very regulations. This is the discrimination the law is designed to stop. Individuals with a disability are no longer second-class citizens. They're entitled. They have a right to live in a home that's equal to everyone else. They can't do that under the Life Safety Code, which was adopted in 1985. The Life Safety Code provisions here were adopted in 1985. That was before the Claiborne Living Center, and it was certainly before the 1988 Fair Housing Act. The federal government did not adopt the Safety Housing Act for handicapped. It's the Fair Housing Act. It is to stop this discrimination. And the only way to stop discriminating is to stop the discrimination. The fire marshal says there's a difference between a fire code and zoning. That's true. The federal government didn't say you couldn't zone. The federal government said, and our state government says, you can impose a fire code on individuals that have a disability that's different than those that don't have a disability. That's the nut of it. All you have to do is compare 4 college students who I would contend are much more dangerous than 4 individuals with mental handicap living in a home. The fire marshal does not regulate 4 college students. It does regulate 4 individuals with a disability. Judge Booser, did you have a question?
No, I was just clearing my throat. Thank you.
She's very noisy, Judge.
So and I think it's most telling, the fire marshal's briefing below and on appeal does not address the law and the case law, both on the definition of family and the meaning of family, which nationwide includes group home tenants. I don't believe there's a state in the union that hasn't addressed this very question and came down on the side of group home tenants are a family. And if you try to distinguish between a nuclear family and those with a disability, you can't do it. Under the federal act, it's the cases that the county cited were all good cases because they addressed the law, and most of them involved the Department of Justice taking the side of the group home tenants. This is the argument that's made in every case. Every regulator says it's for their own good, it's to keep them safe. The fire marshal's regulations refer to these individuals as mentally retarded. they use that term.
Mr. Ford, you would agree with me that if it takes the individuals in a home 17 minutes to leave the home in a fire drill, that's a safety issue as far as the protection of lives. And that would be particularized in this case because that's the evidence that's in the record in this case. Isn't that correct?
Well, that's correct.
Whether a person has a disability or not, 17 minutes is too long.
Yes, absolutely, that's correct.
And for that reason, it would be reasonable for the state fire marshal who has statutory responsibilities in the state of Kansas to prevent deaths from fire to regulate that.
It would, and the Horizons case, Your Honor, addresses that specific point that you make specifically. And the court said it's undeniable that these additional safety measures would make the home more safe for those with a disability.
And you would agree with that in this case?
Yes, as it would for all Kansans. All Kansans would be safer if they had to have sprinklers, if they had to have firewalls, if they had to have steel doors, if they had to have interconnected fire alarms. All these things would make all Kansans safer. Absolutely. But they're only being applied to a certain group, and those people are protected by federal law.
And last couple questions. Do we have any evidence in the record other than the 17-minute fire drill to indicate that the individuals in that particular house could get out of the home sooner than 17 minutes? Any evidence in the record?
As part of our reasonable accommodation request submittals, we acknowledged the fire marshal's concern over the 17-minute evacuation time. And we said that the county had taken steps to reduce the evacuation time. Mr. Carswell has advised the court that the state fire marshal has been advised that those drills the last drill was actually under 2 minutes. That isn't in the record, but Mr. Carswell disclosed that, and Mr. Carswell knows that the county does. But Your Honor, that's not the point. The point isn't how fast they can get out. The point is, was that a legitimate basis to impose stricter regulations? And it's not. And the life safety code doesn't require that. They have gone beyond what the life safety code requires. And I've addressed that in my brief and said, look, even if this was, the 17-minute drill is no good. But your life safety.
Last question. What evidence is there, or is the totality of evidence as to the negative impact, adverse impact of these regulations? The fact that the one owner of the home said, you're not going to put sprinklers in my house, and therefore you'd have people not be able to have occupancy in that particular home. Was there any other evidence in the record to show costs to residents in the event that these regulations are applied to group homes in Johnson County?
The county's reasonable accommodation request and our reconsideration petition went through and detailed the history of problems that have occurred because of the fire marshal's regulations. And there's a 2014 informal attorney general's opinion in the record where the history of these problems is laid out as well as a history of the life safety code. So I think the record is replete with the impact and the hindrance that this causes, but that's not the point, Your Honor. Your Honor, the point is.
Thanks for answering my question.
Okay, we're going to have to wrap it up.
Thank you.
Thank you, counsel. We appreciate all the arguments, and you've given us a lot to think about. Interesting case. And so we'll take it under advisement and get you an opinion when we can.
Thank you for giving us the extra time. I appreciate it.